Well, possibly. So the argument of an unconscionable contract usually takes form as an affirmative defense. And what that means is that so a party sues and says, okay, we had this contract and the defendant was supposed to do X, Y, and Z and did not do those things. And so I'm entitled to damages. Either they have to perform X, Y, and Z, or I get money, or I get some other type of remedy. And the other side can say, no, I never agreed to X, Y, and Z, or X, Y, and Z is illegal because it would cause me to partake in some type of criminal conduct, or the defendant was a minor, so you can't really do that. But if the defendant says, yeah, I executed the contract, there's nothing patently illegal about it. There was no minor. We had to bet what would appear at first blush to be an arm's length transaction. But having said all that, and the plaintiff may be able to prove all of that, it still may not be enforceable because it's unconscionable. So it's used strictly in most cases, unless, like I said, you go to get a declaratory judgment as an affirmative defense. Can you get damages in an affirmative defense? Usually you are relegated to either cost or attorney's fees if you can get those as well. But typically it's not to the point where you would be able to get independent damages based on the other side giving you an unconscionable contract. Now, if there's fraud and it's unconscionable at the same time, then a judge may say, and it may go to a jury as well. But typically these are handled by judges, and a judge may say, okay, well, it's unconscionable, really not entitled to much there other than you don't have to perform. But there's also fraud, and that was pled properly and proven by the defendant, maybe in some type of counterclaim. So based on that, we'll go ahead and get damages. So typically the remedy is that you don't have to perform if it's held to be unconscionable, but it's not where you would punish the other side for presenting an unconscionable contract unless there's fraud involved.